All right, we'll call the meeting to order. This is a special meeting of the Administrative Appeals Board of the City of Palm Springs. I'm the vice chair. Everyone is invited at this point to join in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. And we'll have a roll call from the city clerk.
Vice Chair Howard.
Here.
Commissioner Cleary. Commissioner Cronander. We have a quorum.
Thank you. On the agenda, the next item is acceptance of the agenda. We have a motion to accept the agenda as presented and posted.
Vice Chair Howard, if I could just note, we do have two waivers that we've received, and that's for cases 3 and 4. So they've requested that their items be continued. So today you would only be hearing items 1 and 2.
And the staff's position with regard to the request for continuance?
Thank you, Vice Chair Howard. I received telephonic contact from attorney Lena Wade on behalf of one of the appellants, and I was agreeable to the continuance request in that matter. I did not hear from the other applicant.
I received a request from Mr. Horning requesting that his matter be continued. He's unable to attend today, and he had not previously requested a continuance.
Given the fact that the appellant apparently has provided the waiver of the requirement that we have his hearing within the 45-day period after the citation, I'm not opposed to the board allowing the continuance with respect to the hearing.
Any comments by the board members with regard to requests to continue items 3 and 4? And would that be to a date certain or just?
I believe it would be to a date no earlier than the month of February. And frankly, with the waiver, it's going to be at the convenience of the staff and the board. To be very blunt, I will also note that there will be no agreements on the part of the staff with respect to future continuances at the 11th hour. The board schedules its time, and the staff schedules its time and does its work in anticipation of these hearings. We don't like to waste public resources unnecessarily. There are other matters to address. But as I say, and with the clarification of the city clerk, we heard from these two appellants, no objection to the continuances to a date uncertain.
Is there a motion to amend the agenda to delete items 3 and 4, or should we just wait till we get there and then?
Either way is fine, whatever the board's pleasure is.
All right, well, I would suggest that we accept the agenda as published. When we get to item 3 and 4, we'll address the continuance issue.
Vice Chair Howard?
Yes.
Commissioner Cleary? Commissioner Cronander?
All right, the next item is for public comments. These are public comments to be addressed to the board in general without specific regard to any of the hearings that are on calendar for today. So comments to be addressed to a specific hearing will be taken at the time those hearings come up in order, 1, 2, 3, and 4. However, it is agendized for the board to hear any general comments from the public regard to any issues within the board's jurisdiction. Have there been any requests?
I do have one speaker, Judith Anner.
And this is 3-minute? And Mr. City Clerk, are you
We're
running
gonna
the
have
clock?
to I'll be clocking it.
Okay, all right. Good morning, thank you.
Good morning. Your ordinance item H, the filing of unknowingly false claims against the vacation rental or the guest staying in a vacation rental is prohibited and shall be punishable by administrative fines as provided in Chapter 1.06 of this code. Vacation rental compliance allows anonymous calls to call in to report. Now, if it's anonymous, the owner of a permit wouldn't know who really called in. How can the owner of and if the owner wants to pursue to see who called in, to see if that was really a truthful call, how can he or she can pursue the information of who called, and how can the vacation compliance office can pursue the information to punish the person that is using the city ordinance by just getting against their neighbors? This is just a very big conflict. You have an ordinance with a false that you punish false claims. On the other hand, you're tying the hands of the people that want to find out who really called against you, if you have a permit and you operate legitimately. That's one question. The second question is, and I'll make it very brief, in Palm Springs Villas 2, until a week from Saturday, the CCNR says no transient on hotels. The city issued permits to...
I'm sorry, it says you're Palm Springs...
Villas 2.
Villas 2, is that where you live?
Yeah, right.
Okay, and you were saying that there was...
Right now, until next week, a week from now, January 13, where the membership will vote whether to amend the CCNRs to allow less than 28 days or not. Right now, it just says no transient or hotel. It doesn't even define a certain amount of days. Now, the city issued permits that covers people that operate for many years, that the entire 2018. What would the city do if it doesn't pass the amendment to allow? Would the city revoke those permits? In other words, if the membership says, no, we are not open up, we will not amend the CCNR, we will not allow less than define transient and hotel, and you can rent out for 28 days or more only. What will the people that pay to the city $900 for permits, and a number of them did already, that covered them until the end of 2018, what are they going to do? The city is going to refund the $900 and revoke those permits? We are in a conflict here.
So if people who've already applied for permits...
People that had permits for years and operated for years and paid whatever was before $200, and they are operating for years and they have repeat clientele, and now they pay the $900 because the city increases the permit, and they are covered until almost the end of 2018. But our CCNRs all along from 1982 did not allow hotel and transient. The city gave it was lax. It wasn't what happened in the last year at all. Most people, so those small group have permits that they paid the city $900 before January 1st.
All right, I'm sorry,
renewal.
Your time has expired. Thank you. We are able to hear comments at this time, but not able to engage in a dialogue, answer questions, or things of that nature. So we thank you for your comment. Any other public comments?
No other public comment?
Moving on to item 1 on the agenda. This is a hearing on the appeal of the administrative decision that Lyrics H. Pinchovsky is permanently ineligible to operate a vacation rental in the city of Palm Springs, and the administrative fine for operating an unregistered vacation rental property located at 2077 South Navajo Drive in Palm Springs. So we will open the public hearing and have a staff report at this time.
Yes, thank you.
Good morning.
Good morning. Ms. Pinchovsky has requested an appeal of the permanent ineligibility to operate a vacation rental in the city of Palm Springs and the administrative fine of $5,000 for operating an unregistered vacation rental at the property so mentioned, 2077 South Navajo Drive. Ms. Pinchovsky is the tenant of this property. The owners on title are Mr. and Mrs. Silber, and I would like you to know that Mr. Silber is here today as well. The property has not been issued a vacation rental registration certificate by the city. Staff has determined that the tenant has advertised and operated the property as a vacation rental. The staff report that you have does include the citations from our Vacation Rental Ordinance 1918, under which the citation was issued. There was an advertisement of the property that was found October 6th by our office on Airbnb. The property was being advertised as Renaissance Retreat under advertisement 195-89864. The advertisement included reviews from guest stays, information around check-in time, check-out time, sleeping arrangements, and so on. Our office did send an inquiry on October 5th to see if the host would allow a short-term stay between December 15th and 18th, which was 3 nights. And the host did respond that the home was available to book. Based on the advertisement information and the inquiry about the property being offered, we did issue a citation number AB0026 in the amount of $5,000 to the owners on title. The administrative citation was mailed to the mailing address located on the report, and receipt was confirmed. Mrs. Silber contacted our office after receiving the administrative citation to say that they had a long-term tenant at the property and that she and her husband were not aware that the property had been advertised as a short-term rental. I had subsequent conversations with Mr. Silber, and on November 10th, he sent a letter to our office. It's on page 39 of the staff report, and that does confirm that the owners were unaware and had not provided the tenant authorization to operate a vacation rental. Based on that information, our office voided administrative citation 0026 to the owners and issued citation number AB0053 to the tenant, Ms. Pinchovsky, and that is on page 21 of the staff report. We mailed that and receipt was confirmed, and I'm happy to answer any questions that you have.
Any questions of the staff report?
Mr. Chair, I have a few questions.
Proceed.
Hi, Ms. Severin. Good morning. I had a question about some of the response that the homeowner gave regarding people at the city who had advised her about obtaining a use permit. Is that change of use permit? Can you explain how that might have occurred?
My understanding of that, because I did talk to Ms. Pinchovsky after the citation was issued to the owners, my understanding is that she had contacted another department within the city because there was interest in some other type of business. I would suggest that you talk to her specifically, but the information that I gathered during that conversation, and she did come into the office, and I spoke to her personally. And again, I had not spoken with her before then, was not aware that she had contacted our office, but she explained that she had reached out to another city department to get information about running a particular type of business in that home, not a vacation rental.
Okay, so that's why there's the reference to the building and safety department. Is there a building and safety department in the city?
Yes, there is.
And is somebody named Angela employed at the building and safety department?
Yes, there is.
Okay. All right. And there was a permit issued under, a change of use permit issued actually to Ms. Pinchovsky?
I can't speak to
Okay.
that. Our office doesn't issue those.
Okay. All righty. Thank you.
You're welcome.
Any other questions of the staff report?
Mr. Vice Chair, I'd just like to add, having perused the staff's agenda packet materials, I don't see that there are any facts in controversy in this case whatsoever. I think that the matter is very straightforward, that there's been a clear violation. We're certainly available for questions, but obviously you'll want to hear from the appellant.
Ms. Severin, did you say the inquiry was October 5th?
The inquiry was October 5th for the dates of December 15th through the 18th. Yes, our officer did make an inquiry before we issued this citation to the owners.
I just noticed, though, that was a day before the date of the posting that you referred to, October 6th.
Mm-hmm.
So what prompted the inquiry a day before someone noticed the posting?
Our officer, we track leads that we investigate, and our officer, he's not here today, but it is not uncommon for our officers to continue their investigation and print and do an inquiry before or after they print the ad, and I believe that's what happened.
Okay. All right. Any other questions of the staff report?
No, thank you.
All right, so at this time, we'll hear from the appellant for any further presentation, and I believe that's 10 minutes. And so if you would give us your name and then proceed with anything you'd like to present in support of your appeal.
Good morning, everyone. My name is Lyrics Pinchovsky, and if you excuse me, I'm a little nervous. It's my first time. So to answer your questions, long story short, we rented the property from Mr. Cyber back in June. We had a 3-year lease agreement. Mr. Cyber did know we rented the property in purpose of using it as a business.
June of 2017?
Yeah.
Thank you.
Yeah. The intention of using the property is for board and care, basically, assisted living. It was never meant to be used as Airbnb, but as you can see, we got incorporated and everything we needed in order to get a license for a retirement center. However, the process takes long, and it can be up to a year till you get your license. So we had to figure out a way to pay rent meantime and pay our expenses. So we've decided to use it as Airbnb. Before we uploaded the listing on Airbnb, I read a little bit. I have no knowledge about Palm Springs and rules and regulations. I am from LA. I figured it's my bad that I figured that it's the same states, it's the same rules as in LA, and I was wrong. However, before I posted the listing, I did go to the city myself. Basically, I self-surrounded. I told them of my intentions. I spoke to Debbie, And another representative, I don't know his name, he has glasses. I told him that I leased this property and I'm intending to use it as a retirement home, and meantime I'm using it as Airbnb. What is it that's required of me? Because I did go online and the information was confusing and overwhelming, so I decided, in order to prevent any mistakes, to just go directly to the city and speak to them so they can guide me of what to do. So Debbie and the other representative told me that all I need is a business permit of a change of use, which at that very same day, I filed right away for a change of use. And you can see the receipt from August 14th, where I paid for the permit, for the business permit change of use. Not only that, I was required to provide a floor plan, which I did, and it was a lot of back and forth between the sheriff and Angela from Building and Safety Department, a lot of back and forth, just so it turns out at the end of the day that I did not need that permit. So I don't know if it was miscommunication. Basically, Angela told me that they got confused between the Airbnb and the retirement home. These are two different requirements, and there was a lot of miscommunication, and they got confused. Basically, I never meant not to comply with the city. I went myself to the city to tell them I want to do Airbnb and I'm doing retirement home. Airbnb is going to be temporary till I get my license. I never operate without a license, which is the reason why I'm not active as a retirement home yet, because I haven't received my license. I don't go against the rules and regulations. I have a lot of respect for the rules and regulations. I never intended not to comply with the city. I went to the city. I've been active towards the rules and regulations ever since day one. As soon as I heard from Mr. Cyber that we got a citation, honestly, I was shocked, because I thought this whole time I was doing what I've been told. And I went online and I did some research, and you can see I even took screenshots that a lot of the government pages are not working. They don't show up online. So I did not have all the information I need. I physically drove here from LA to spoke to Miss Suzanne to ask her, can you advise me what to do, how to move forward? Because I'm getting so much conflicting information between all the departments. I've been dealing with so many different people getting conflicting information. So this is an honest mistake, nothing more than that. I never meant not to comply. Once Ms. Suzanne told me what to do and to appeal the citation and involve Ms. Cyber, I complied all along till this day. So never once did I not meant to comply. I've been told to issue a permit, I issued a permit. Then they canceled the permit. And if you can see in the paperwork, you see the check from the city that I got as a refund, because Angela informed me that I applied for the wrong permit. There's been a lot of confusion between them because there's a lot of new rules and regulations that I don't think they even know. But this whole thing created, and you can ask Angela, she even told me, it created a whole confusion between the retirement home and her Airbnb. But it did tell the city from day one, I'm doing Airbnb, a retirement home. What is it that you need of me before I do anything? And I went there before I even posted the listing on Airbnb. I thought I was in compliance. Turns out I wasn't, never meant to. So that's basically what I have to say.
Thank you, Ms. Pinchovsky.
Thank you. Do I sit down?
Yes. And City Clerk is absent, but I'll ask if there are any public comments to be heard specifically regarding this appeal. Did you notify the clerk of your request? And what is your name, please?
My name is Peter Brown.
We'll need Mr. Brown to fill out the speaker card.
I did fill it out. I gave it to this gentleman.
Your
Not sure that the clerk's office hasn't changed the policy. We had a separate form for interested parties, that is for appellants versus interested speakers. I have the form here for Mr. Brown that appears to be the appellant form. He's not the appellant. Correct.
Does it, does it acknowledge that the comments constitute testimony under penalty of perjury?
Yes, I believe it does.
Yeah, why don't we do that then?
That'd be great.
Commissioners, I just want to note that Ms. Pinchovsky submitted these to our office. These are the documents that she was referencing during her testimony.
Mr. Chair, I don't see the oath that should be on this card. So with your permission, before Mr. Brown speaks, we'll recall Ms. Pinchovsky, have her take the oath with the clerk or with me if he's not here.
Oh, the appellant form doesn't have
The
that
appellant
item?
form, this green form does not have an oath on it. And as a consequence, Ms. Pinchovsky didn't take an oath with respect to her testimony.
All right, well, when,
I
I don't think we have any strong feeling of how it's accomplished, just so we,
if you don't mind, I'll drive the bus for a second.
fine?
Thank you. So, Ms. Pinchovsky, if you can resume the podium, please. Ms. Pinchovsky, we've had a change in our city clerk's office, and with that change, the form that had been utilized at this appeals board with respect to appellants and the separate form which had been used with respect to speakers seems to have changed. The form that we have today does not contain or reflect an oath and an advisement to you that all of your testimony is under penalty of perjury. So I'm going to ask you a question. Do you swear that all of the testimony that you give today and all of the written documentation that you submit today, apparently there's new written documentation you wish the board to consider, do you swear that all of it is the truth, the whole truth, and nothing but the truth?
I do.
And that would apply to all of the testimony, oral and written, that you've given here today.
Correct.
Prior to this moment, correct?
Yes.
All right. I'm satisfied with Ms. Pinchovsky's oath. We'll administer the oath to Mr. Brown when he takes the podium.
Mr. Brown? What is your first name, sir?
Peter?
Peter Brown.
So, Mr. Brown, do you swear that any testimony that you're going to offer to the Administrative Appeals Board here in the city of Palm Springs is the truth, the whole truth, and nothing but the truth?
I do.
Thanks.
All right, Mr. Brown, you have, is it 3, 5, or 10?
As an ordinary speaker, I believe that the board's practice has been to give 3 minutes.
All right, sir, go ahead.
Thank you for hearing me. I have no expertise in the matters at hand. I have administrative experience in a fairly decent amount of administrative experience dealing with tax administrators at federal and state levels. And what struck me, and the only comment I wanted to make, was that when it comes to interest and penalties in most administrative matters that I've dealt with in my professional career, immediacy, openness, and acting upon first receiving information has always been critical to the dismissal of penalties and to the acceptance of an appeal. And in this case, I'm struck by how in every step of the way the appellants not only sought administrative assistance, but when they found it to be lacking, they took immediate action to correct the situation. And so my only comment is, in the 30 or 40 years that I've dealt with federal and state regulators, immediacy and the reaction to facts as they developed were always critical, not to the resolution of the case, but to the waiver of penalties, interest, and interest. And so I just wanted to make that point. All I've seen is an immediate action every step of the way when the appellants discovered that they were perhaps not operating on as solid a ground as they thought they were. So that was my only point.
Thank you.
Ms. Pinchowski, if there's, you have an opportunity for rebuttal to any public comments.
Sorry, I just forgot to mention something. Once the citation against my landlord was waived, I called Ms. Suzanne and I asked her if it's okay if we can apply for a certificate now. And she explained to me, since I have a citation against me, we cannot, even though he's the landlord. So I really, truly, once I realized there is a citation, the city never even told me there's a dedicated department for vacation rental till after I got the citation. I even went and talked to Debbie and I'm like, how come you never informed me of this? It's like, honestly, we kept thinking about the retirement home. I'm like, but I told you Airbnb. But never mind, really, the second I realized I need a certificate, I tried my best to see if I can get a certificate. So never once did I even meant to operate
your
without
comments at this time need to be limited to responding to
I'm
Mr. Brown, if anything.
Okay,
So
thank
thank you.
you.
All right. Board members, any questions of the appellant?
Mr. Vice Chair, there's been a packet of materials submitted to me.
Yes, so this packet, Ms. Pinchowski submitted this via mail. This is the 10 written documents that are the 10 copies for everybody at the dais of written comments that she wanted to provide to the
I
commissioners.
just wanted to note that for the record. I'm not sure exactly how many pages this document is, but the city clerk has represented he's provided all documents received from the appellant to both the board members and made them available to the public per the Brown Act.
Thank you. Board members, any questions of the appellant?
If the chair doesn't mind, I have a few questions for Ms. Pinchowski.
Go right ahead.
Ms. Pinchowski, it'd be easier perhaps if you just took the mic. So I'm trying to understand kind of the sequence of events that led to you being here before us today. And I received a packet, and I wanted to just make sure I have everything that you wanted us to see
Okay.
in today's hearing, so that you have a full and fair opportunity to explain yourself. So in the original packet, we did receive the copy of your citation, and we did receive your letter of explanation or your defense to the citation previously. So we've already had a chance to review that because the board members were provided with that in advance of the hearing. And then what looks a little new to me is there's a written notice of appeal form, but the attachment is like I said, the letter of explanation, which basically your explanation is that you made a colorable attempt to comply with the ordinance that you didn't know existed, but because you were applying for a retirement home permit, that some of the things that you did in that line of work would qualify under the ordinance. Is that basically?
I'm not sure I understand your question. I'm sorry.
The reason that you're arguing that you shouldn't be cited is because you substantially complied with what the ordinance
Right.
requires.
Yeah, I went to the city and told them my intentions of what I'm want to do with the property and ask for guidance. So yeah, I did not know, but I didn't just sit around and not do anything. I went myself to the city to ask for help. What is it that you need from me in order for me to comply? Is that answering your question?
Yeah. Well, you're basically your defense is that you kind of applied for the wrong permit. Basically, that
I guess I applied for the wrong permit, yeah, because they refunded me. So
you're still intending to open a retirement home. Is that your?
Yes.
And the permit you required in that case is from the city, and it's pending. Is that right?
No. So it turns out I don't need a permit. I spoke with the sheriff. I forgot his name. City of Palm Springs. You see this form? I already had a permit number and a plan checker. And both sheriff and plan checker told me that it's actually illegal to ask me to do a change of use permit, that I don't need it for a retirement home. So they canceled the permit and refund me the money.
So I saw the
So I don't have a permit.
Okay, so you had applied for a change of use permit, they inspected your property, it had to have certain exits and fire extinguishers, et cetera.
No, they haven't inspected the property yet. That they need, from the state, they need, once I apply the application for the license from the state, I think, the state needs to call the fire department to come for an inspection. We didn't get that far.
Oh, okay. I thought I saw something in there. Okay.
No, they just asked me for the floor plan, and we went back and forth on corrections I needed to make on the floor plan. Then the city issued the permit, and then the fire marshal heard it, and he told them to cancel the permit because there shouldn't be a permit for that.
Okay, so have you operated a retirement home in the past?
No.
Were you aware how long it took to get permitted to open a retirement home?
I keep hearing different stuff, but basically I've been told roughly it's about 6 months.
So it was your decision that during that 6-month waiting period that you'd do Airbnb
Right.
to make up for the...
For the money, yeah, for the expenses.
And your testimony is that you told the city when you were applying for your permit for the retirement home that you were going to do Airbnb as well.
Right. I told them I told them exactly what I'm telling you, that it takes time till I get my license, and meantime I have to have some means, So I need to use it as Airbnb. What is it that you need of me? That's exactly what I said.
And in the permit, when you applied, is there anything on the permit application that says that you're going to do Airbnb?
No, but I don't think it even says anything about a retirement home. I never seen the permit. I've never received the permit. I just saw I have a permit number. Like it's been a lot of miscommunication, a lot of frustration, a lot of people dealing with this case, a lot. Like I've been dealing with a lot of people, the fire marshal, the plan checker, Angela, Debbie, the other guy who works for the city, Miss Suzanne. So there's been a lot of miscommunication from a lot of parties. Yeah.
So you paid the transit occupancy taxes that were due based on the Airbnb rentals you had done?
Yeah, I haven't been charged, but I paid. They told me they're not going to charge me till the hearing to see what's going on with the hearing. But I have receipt. I mean, they stamped it. You can see it there.
And the pages that you included that show like screenshots?
Yeah, that the government website didn't work when I wanted to research and get some more information.
When you went on to the Palm Springs city website?
Yeah, to get more information about the whole Airbnb thing. This is after I got my citation.
Yeah, it's in the packet that we just received, and do you have it? And it looks like there's little icons at the bottom, and you can see it's a screenshot on Safari.
Mm-hmm. And does it have a date?
The only date I can see is down at the bottom. It says November 16th on the calendar icon, but I'm not sure if that always says November 16th or if it rotates.
It's been several times. It's just that when I started, after the citation, I knew I need to collect, supporting evidence. So I went back on it and took a screenshot on that day.
On the day after you received the citation.
Well, we received 2 citations. Like, my landlord received the first one, and I was helping him deal with it because he didn't know what was going on, so.
And were you ever able to get onto the website of the city and
to get information? Yeah, I think you guys just updated it said something after January, the rules have changed, or there needs to be an inspection, something like that. So it keeps changing. As I said, to me, it's very confusing. I don't know why. It's confusing. There's a lot. It's overwhelming. Let's just say that. There's a lot of demands, a lot of regulations. So I thought if I go physically and ask you guys, this way I won't make any errors, any mistakes, and it would be pretty straightforward. You know what I mean? So I didn't just trust myself in the website. I'm like, I'll go there myself and just do what's needed.
And then you also included the vacation rental requirements. You wanted us to see those?
Right. So because I've been told I wasn't in compliance, which I totally understand because I did not have a certificate. But you can see, if you look through the paperwork, how I've been active since day one before I even listed the listing on Airbnb. I came for a business license, and yeah, granted I didn't get it because it was waived, this whole confusion, but I have a corporation, I've paid my taxes, can't say I'm not in compliance. I have tried to be compliant all along, so that's just basically what I'm trying to show.
Okay, I think that's all the documents. Thank you.
Mr. Cronander?
Yeah, I just have a question in terms of the timing, the sequence of events. I understand that you went through this whole procedure with respect to the change of use that you didn't need to go through. That seems to me not to be relevant to the issue before us now. So my question is, when did you go into the vacation rental department before you advertised your property on B&B? Or did you only go in to talk to these folks after you received your citation?
After I received my citation.
So you did not have a vacation rental permit at the time that you rented out the property, is that correct?
I did not, but that's exactly what my case is. I went to the city prior to the Airbnb listing.
But not to the vacation rental department.
I did not. They never told me there is a vacation rental department. I thought I was dealing with everything with Debbie and the other representative that was there, because I told them I'm doing Airbnb in a retirement home. What is it that you need of me? So Debbie told me pretty much we put emphasis on their retirement home, but I didn't know that. I didn't know that it's not.
Say again, put emphasis
on the retirement home. So they got it confused, the retirement home, Airbnb. Even Angela told me they got it confused. There's been a lot of miscommunication because I needed two things done. So they never referred me to the vacation department. I only went there after I received my citation. That's when I found out there is a citation, there's a department for that. Then I went to the city because I was outraged. And I told Debbie, how come you never told me there's a vacation rental department and that I need a certificate? She said, I guess I got confused because we kept thinking about the retirement home. So.
And those were the people over in the other department that were
Yes.
telling you that?
Yes.
You know when approximately you went to that other department?
August 14th.
August 14th.
I've been there several times. The first time where I told them of everything, you can see where I paid right away. I told them I'm doing Airbnb and retirement home. What do I need? They told me a permit of change of use. You can see the receipt I paid on August 14th when I was there for the first time.
But that was for the change of use. That wasn't for a vacation
That was for
rental.
both. I didn't even need a change of use, apparently. That was for both. I thought that was for both. Apparently, that's for none of it. I still don't know what I need for a retirement home. I go to the city, I ask for guidance. Apparently, everything I've done so far was useless. I spent time, energy, and money on something that I don't even need. But I asked them for guidance. Can you please tell me what you need of me? And I did everything they told me.
With respect to the change of use.
Yeah, well, apparently I didn't need a change of use.
Right. But you're here today before us not with respect to any of the change of use issues for the permit, but solely with regard to operating the property
Right.
without a rental permit.
Right. This is just an explanation of why I didn't have a permit, a certificate.
I have no further questions.
Do you have any document that shows prior to your listing of the property as a vacation rental, do you have anything in writing constituting notification to the city of your intention to use the property both for a retirement facility and as a short-term vacation rental?
All I have is the receipt from August 14th that I was there, but I'm sure if you ask Debbie or Angela, they will tell you that I told them. That's all I can say. I didn't know I need to write it down for them. I didn't expect any of this. I literally just came, tell me what you need from me, you know. I didn't know I need to write it down for them. I didn't expect any confusion because of it. All I can show you is the receipt that I was there, and I'm sure if you ask Debbie or Angela, they will tell you that I told them.
Any other questions of the appellant?
I have no further questions.
All right.
I have no further questions of the appellant.
Any further information from the staff?
Well, I'd like to make a comment or two, and I know that the staff would like to respond to some of the things that have come up on a factual level. As we've discussed in prior hearings, the business of short-term vacation rental is a highly regulated area. It's a very sensitive use in our community. The City Council spent a very, very long time making sure that this ordinance walked the middle path between people who don't want vacation rental in our community and the people who want there to be completely free and easy, unregulated vacation rental, and everyone in between. We had to find a way to aggressively regulate a use that is sensitive in our residential communities, and the ordinance is our best effort. We think it's going very well. It's interesting that this particular appellant is trying to get into the business of long-term care, residential long-term care. That's also a highly regulated area. My comments for the appeals board really revolve around the fact that regulation is a complicated business. And when you want to do things that are regulated by the government, you have to be very careful. I have very little doubt that having been sworn in, I think we will need to take Ms. Pinchowski's oath. I think I neglected to do that. I did it with respect to... No, I did that actually. I do recall doing it. I have very little doubt that she's telling you the whole truth from her vantage point. I think that there may be some things that she's forgotten, but I have no doubt that she's being truthful. She's from LA. She didn't know. She came in. She was trying to get it all done. But if you go to the DMV and you ask them to give you a liquor license, that doesn't work. And as a practical matter, you can't go to the building and safety department and ask them to help you with short-term vacation rental. So
it wasn't the city, the building and city.
Excuse me, you can have a seat. And okay.
These are highly regulated areas, members of the Board of Appeals, and from my vantage point as the city prosecutor, and I hope from yours, ignorance of the law is really not an excuse or a defense. She didn't know, she didn't intend to operate a vacation rental without a permit in violation of our ordinance. I'm sure that's true too. But the evidence, as I said before any of it was presented, based on the materials alone, it's pretty much uncontested what's happened here. There's been a clear violation of the ordinance, and the appellant in very clear detail told you how and why from her vantage point it happened. We, the city of Palm Springs, cannot abide illegal operation of short-term vacation rentals, and that's why we have this ordinance in place. I know staff would like to respond to some of the factual elements of the case, so I'll defer to them.
Thank you. I appreciate that Ms. Pinchowski is working on a permit for a retirement center, and I respect that. I appreciate that very much. And I wish her luck with that. But our issue is whether or not she operated a vacation rental, advertised and operated a vacation rental without a permit. So I just want to focus on that for a minute and just say that operating without that certificate is illegal. We've had a program in Palm Springs since 2008. While I understand that city staff across the board isn't specialized in everybody else's department, I do believe that city staff in general knows that operating a vacation rental without a certificate is illegal. And the other thing that I want to point out is that I have explained to Ms. Pinchowski several times that she's not the owner of the property. She's not going to be able to get a vacation rental permit because the applications come from the owners, or they come from an agent, an agency on behalf of the owner. So she's not eligible, and I just wanted to make that clear. And having said that, a couple dates I want to point out to you. So the permit that's in the package that we got this morning, Permit Center, City of Palm Springs, what is it, page 12? Page 12 shows that there's a customer receipt on August 14th of 2017.
Sorry, so the record's clear, Ms. Severin. Are you referring to page 12 of what we got from Ms. Pinchowski or page 12 of the packet?
Yes, what we got from the city clerk this morning, the package that he handed out.
From Ms. Pinchowski?
Yes.
Members of the Board of Appeals.
Yes.
I just wanted to make sure we're all on the same page,
Yes.
quite literally.
Thank you. So the date on that is August 14th, 2017. And if you go to the staff report that we prepared, page 31, it shows that the ads started in June of 2017. And in fact, there's a guest review as early as August. So we have the ads. We actually have hotline calls that came in that prompted our investigation. There was activity at this home around an illegal vacation rental. We have the ad, we have guest information, and it appears as though this started on or about the same time as the other permitting.
And in conclusion, Mr. Vice Chair, members of the board, I made the analogy to the DMV and the liquor license with the very specific intent of sort of, by hyperbole, illustrating a principle. You can't address apples where they sell oranges. And when you enter into an activity that's highly regulated, if you want to buy an apple, you got to go to the Apple store. That's not to say that Ms. Pinchowski meant to violate our ordinance, but it is to say that as much as she may have in her heart intended to comply, on an objective level, she wasn't as careful as we would like her to be. That's it.
All right, that's it from the staff. And
Sorry, thank you, Vice Chair Howard and members of the board. I do just want to address real quick, the Vocational Compliance Department has had the website up and running since probably early this year, 2017. We have received no complaints that the website is not accessible or inactive or any documents on there. We publish a weekly call log report. There is over 2,000 vacation rentals in the city of Palm Springs. They utilize our website. We have not received one complaint of a website not being accessible at any point of time within the last year. Thank
when
you.
did that start?
Our website was up and active January 2017. Thank you.
Thank you.
May I have a question for the city?
Okay.
Is that appropriate at this point?
Any objection?
Just as a clarification, I don't have the ordinance in front of me, but as a long-term renter, will you confirm to me she can't have a permit?
She's not eligible.
If she had walked in and applied for the permit in a timely manner, she still would not have gotten it.
Even if we thought she was the best candidate in the world
Okay,
to
I just wanted
operate a vacation
clarification on
rental, she can't do it as a long-term tenant.
All right, so on this appeal, the evidence is closed at this point, and we will have discussion among board members.
Just for the kind of summary, I think that what's clear is that I don't think there's a dispute that the unit was rented without a permit, as Mr. Calkin summarized. The issue is for the appellant is the defense of substantial compliance, that she had applied for a permit. It was a conditional use or change of use permit, but at the time, her testimony is that she told them that she wanted to do Airbnb. We don't have any testimony from the city to dispute that, and we must or can take the appellant at her word. She's under oath. I believe that that's something she did, and but she was in the DMV asking for a liquor license is the problem, and who should that fault fall to? Not only is vacation rentals highly regulated in the city of Palm Springs, but I can't imagine the amount of regulations that go towards elder care facilities or retirement homes. I mean, how many departments must be involved in the state regulating that? The amount of homework you're going to have to do is going to be substantial. So I know that you indicated in your defense that you had done research regarding this, and I know that there's been a lot of people complaining that this ordinance has been not properly notified for out-of-town people, and you're an out-of-town person. You're from Los Angeles, but I think that you obviously went into the city and paid a substantial permitting fee to obtain a permit in an attempt in good faith to operate legally. It didn't cover you in this situation is the problem, and the question is whether or not your substantial compliance is grounds to set aside the citation. And my only thoughts for the other members of the board is that your attempt to go into the city, it would seem that would be the correct place to go if you're trying to operate a business in the city of Palm Springs, including vacation rental, and that misinformation that occurred. I mean, where are you supposed to go to get this information but the city? So it's flabbergasting to me that they would allow you to leave without understanding your obligations and this new big ordinance that has been taken off a huge amount of time for the city and the city council and the citizens. It's been a large issue here for a long time, and so I would think that everybody within earshot would have told you about what the requirements are. But the fact is that you were there. I believe you were there. I believe that you discussed it and you were given bad information. I think the other board members and council members here should consider that in deciding whether or not your appeal should be sustained or denied. That's my comment.
And just to clarify, the communication between the city and the appellant that you're referring to was the permit application that occurred in August?
Yeah, the August 14th date when she was obtained a City of Palm Springs permit for change of use.
Mr. Cronander?
Well, we know already with respect to one part of the citation is already in a sense irrelevant because she's not allowed or never would be allowed or never would have been allowed to have a short-term rental. So I think what we're talking about is primarily the amount of the citation. It's already agreed that you're not allowed to ever in the future rent this property out because of the way the ordinance is structured. I still go back to the fact, and I know there is some confusion about what the planning department may have suggested, but in other cases that we've looked at, it has always been the appellant's responsibility to get the right information. There is a website. I understand you walked into the wrong department and may have gotten some faulty information, but be that as it may, there are plenty of places to go, and it's really easy. I know I've been on the website. Simply to type in under the City of Palm Springs rental department, and all the information pops up along with, I believe, a summary of the information so that you don't have to plod through the entire, albeit quite long and complicated ordinance. I just am very leery of starting now to set a precedent that may be used later, that the defense of "I didn't know" is a valid defense. It is the responsibility for complying with the ordinance is 100%, in my opinion, on the shoulders of the person applying for the short-term rental permit. It's unfortunate that there may have been some confusion as to what you heard at a different department in the city. But again, I believe it's your responsibility. And there were other ways to find out what your responsibility is to do that. And had you read the ordinance, you would have found that you weren't even allowed to do it, period, much less with a permit. So I'm sympathetic with the confusion that you feel resulted in where we are today. But again, I'll repeat myself, it's your responsibility, not the city responsibility, to make you, to be aware of the requirements in the rental ordinance. Thank you.
Thank you. My comment would be that I don't find this to be a question of substantial compliance. I do find it to be a case of no compliance. The two actions are incomparable. The overture to the Building and Safety Department versus the absence of any addressing the short-term vacation rental. They're not comparable, and in any event, that communication did not occur until after there was already short-term vacation rental activity underway, which the staff has documented. So I don't see that conduct in August can be taken by us as compliance with an ordinance that conduct in August cannot be used as an excuse for conduct that occurred 2 months earlier. I think, you know, it would be nice, I suppose, if City Hall here, right inside the front doors, there were a desk that said, "Welcome, and we're here to serve you. And sit down and have a drink of water and tell us what you want to do." And somebody could say, "Well, I just moved here, you know, and I have these 6 issues, and I want to do the right thing." And that somebody would be charged by the city with the responsibility of making sure that that person was directed so they could put themselves in full compliance. We just don't have that. I don't think that that's an intended function of the government of this city. And there are examples of it throughout our government at all levels where it can be complicated to navigate, but I don't think as has been said, an inquiry to the Building and Safety Department is going to carry the day for this appellant, at least in my view. Any other comments? All right. So is there a motion with regard to the disposition of this appeal?
Mr. Chair would entertain a motion. I would make a motion that we deny the appeal based on the comments made from the city and other council members. However, impose but stay the fine based on perhaps not a defense of substantial compliance, but in mitigation. That and I believe that she, if she was correctly, if she wanted to obtain a vacation rental permit, she could have, with the homeowner's permission, she could have applied and obtained one if the homeowner had submitted an application. So it was not absolutely impossible for her to engage in this. So if the chair would entertain a motion to deny the appeal, impose the fine, but stay it based on the evidence we've heard, that would be my tendered motion in this case.
Mr. Vice Chair and members of the board, as you consider the motion by Board Member Cleary, I just want to let you know from staff's vantage point and from my vantage point as the city prosecutor, it is absolutely impossible for her to get this permit. She can't get this permit as the tenant. The only way for a vacation rental permit to be issued for this property is if the owner or an authorized agent of the owner comes in. Now, in abstract theory, I guess she could be an authorized agent of the owner, and they could have a contractual agreement whereby she was somehow entitled to the owner's benefit from the vacation rental, but there's just no way. We would not take an application for a permit from a tenant absent some bizarre and extraordinary circumstances.
Let me note also that the residential lease that is part of the staff report at paragraph 1B states that the premises are for the sole use as a personal residence. And Mr. Cleary, a question on your motion. You use the term stay. Are you talking about a stay of enforcement or granting the appeal as to the $5,000 fine? It sounds like you're saying grant the appeal as to the $5,000 fine.
I guess that's what I would amend the motion to say grant the appeal as to the $5,000 fine.
And
so I guess the motion would be to deny the appeal as to the ordinance operating, find that there is a violation, but to grant the appeal as to the imposition of the fine.
I wonder if there's, you find support in the ordinance that gives us the ability to do that?
I would have to defer to Mr. Kotkin.
Well, I think we would be in that conflict area if he were to comment, and I don't want to tempt that. But in his position as an advocate for the city, would you like him to respond? Any objections?
I'm sure he'll give us an honest answer.
No, that I appreciate that, and I appreciate the sensitivity, Mr. Vice Chair. I'm working on the city's behalf here. I am advocating that the board deny the appeal on both grounds. I would indicate to the board that if it wasn't in abstract theory possible for the board to deny the appeal with respect to the citation and the fine, we wouldn't have these approaches to these appeals that we present to you. You can take those actions if you wish to take those actions. The bottom line is that we do not exercise prosecutorial discretion as we can and in fact do in other regulated areas with respect to these vacation rental issues. And the reason that we don't is that these particular uses are sensitive, are highly regulated, and as a practical matter, the appeals board has the equitable jurisdiction to address this matter any way it sees fit. What I won't do, even as an advocate, is affirmatively mislead the board. But the flip side of that is I would strongly discourage you from doing that as the city prosecutor fulfilling my role, because it sets an incredibly dangerous precedent with respect to this ordinance. The fine is intentionally high. The fine is intentionally at a level that it impacts very severely, and it's been working. The ordinance itself is working. Staff can give you, and perhaps should give you at some point, an administrative update on the progress that has been made here in the city based on the ordinance being in place. But I would strongly urge you not to exercise any equitable jurisdiction with respect to the appeal before you and mitigate the fine. I would emphasize again, as I have previously, that we work with appellants. We work with people who have violated this ordinance, because as much as we have a strict standard here, we're also human beings, and we'll certainly agree to a payment plan as we do with any person who violates this chapter.
All right, let's see if there's a second for Mr. Cleary's motion, which is to uphold in effect, it would be moving adoption of 2A and 3B, correct, Mr. Cleary?
Yes.
Is there a second for that motion? Hearing no second, the motion fails. Is there any other motion?
I'm quickly looking through the actual numerical. I would move that to adopt the resolution under 2A and under 3A.
Very good. Is there a second? I'll second the motion. So it's been moved and seconded that the board adopt resolutions 2A and 3A. Roll call.
Commissioner Cronander?
Aye.
Vice Chair Howard?
Aye.
Commissioner Cleary?
Aye.
Motion, Mr. Clerk?
Motion passes 2-1.
Thank you. Staff ready for moving to the next item on the agenda. Which would be item 2. This is an appeal of the administrative decision that Brenda M. Walsh. I apologize, Mr. Walsh. Thank you. Let me start over. This is an appeal of the administrative decision that Brendan M. Walsh is permanently ineligible to operate a vacation rental in the city of Palm Springs, and the administrative fine for operating an unregistered vacation rental property located at 1415 North Sunrise Way, number 52 in Palm Springs. We'll ask the staff report at this time.
Thank you, Vice. Thank you, Vice Chair Howard and members of the board. Brandon M. Walsh is a property owner for the property located at 1415 North Sunrise Way, Unit 52 in Palm Springs. That location has not been granted a vacation registration certificate by the City of Palm Springs as of the date of the administrative citation that was issued on August 21st, 2017, or any time in the past. Staff has determined the owner has advertised and operated.
A little slower, Mr. Stark.
No problem. Staff has determined that owner has advertised and operated the property as a vacation rental. Advertisement of the property located at 1415 North Sunrise Way, unit number 52, Palm Springs, was found on Airbnb.com under the title Your Place in Palm Springs, under advertisement number 166826. The advertisement of the property and inquiry into the rental of the property includes that on November 9th, 2017, the staff did send an inquiry into the dates of from September 3rd to September 17th to be booked. Go ahead.
Inquiry November 9th.
It says on November 9th, our staff sent an inquiry for the dates of, that is a typo.
I thought you said September.
1 second, there is a, it's August 9th. 1 second, please. On August 19th, correction, an inquiry into the dates of September 3rd to September 17th was sent if the property was available to be booked. The property owner at that time engaged and advised that the property was available to be booked for those dates. The property advertisement does contain 29 reviews dating back to May 2014. It advertises as an entire home, apartment for rent. The availability of the property states that there's minimum nights vary for the listing and offers weekly and monthly discounts. Based on the advertisement information and the inquiry into the property being offered as a vacation rental by the host, administrative citation number ET0009 in the amount of $5,000 was issued to Mr. Brandon Walsh. The administrative citation was mailed by staff to the mailing address located in the title report. Staff does want to note that Brandon M. Walsh has paid outstanding transient occupancy taxes and penalties to the city regarding operating of 1415 North Sunrise Way, unit number 52, as a vacation rental. In addition, Mr. Brandon M. Walsh was offered a corrective action plan that has not been submitted to the Vacational Compliance Department. Please note that the $5,000 fine has not been paid pending the outcome of this hearing. That concludes the staff report. Any questions?
Mr. Vice Chair Howard, before questions are offered by the board members, I'd just like to add, reviewing Mr. Walsh's materials, and I'd like to also add that he did submit some additional documentation today. It appears to be 3 pages. No, is this on Mr. Walsh as well? Okay. 3 pages that he submitted today, and it appears that a couple of them are double-sided, so it's a total of 5 additional pages, which I think the board members have and is available to the public as per the Brown Act. Just like I did in the last appeal, I don't think there are any facts really in controversy here. The violation took place. I don't think Mr. Walsh is going to take the stand and under penalty of perjury say he didn't rent and operate the vacation rental without a permit. I think he's got some explanations he'll probably offer, and this is really much more about what you want to do with the fact that there's a $5,000 citation. I don't think we need to belabor the point of the facts of this case. The facts are what they are. He operated the vacation rental without a permit.
Thank you. Board members, any questions of the staff report?
I have a couple of questions, or one question. I see on your report that the property has 29 reviews dating back to 2014. So the presumption is he was operating this property without a permit even that far back. That is your
that would
position.
be that would be a correct presumption.
Now, when I went to when I went to page 29, I didn't see where it actually shows that these reviews were from 2014, but I may have missed something here.
If you look at page 29 of your packet, there's a review. The last review on that page is dated May 2014.
Matthew and Rodney.
Okay, as long as you see it. I'm sorry, I'm just on 29.
Oh, yeah, yours is different.
Are you in the right case?
That could be a problem. I'm looking at 29. You're 29 different than my 20?
On page 29, the citation to page is correct.
Oh, okay. Oh, okay.
See Matthew and Rodney.
And he's actually joined in 2011, it says down in the bottom. So, okay. So I assume that's when he started advertising. That was just a clarification. I don't have any comments.
Larry? All right. Mr. Walsh, the appellant, you'll come forward And I'll ask,
You
If
have
we're-
the oath of office, the oath.
very good, very good. All right, Mr. Walsh, you'll have 10 minutes to present any further information in support of your appeal.
First of all, I see the special meeting agenda number 2, the name there on section B. Do you see recommendation section B? You have your last client listed there, Lyrics H. Pekonsky, and it should be Brendan Walsh. Do you see that? So that's a typo, I think, again. So I'm appealing the citation to the degree that I'm not denying that I was renting the property. That's not the question. That's not what I'm here for. And the prosecutor's made his argument, and I'm not disagreeing with it at all. I did advertise, and I didn't have a certificate. My arguments, I have a couple of arguments from different points of view regarding as to why I wasn't aware of the fact that I should have had a certificate. And I have some evidence regarding what I've done in the meantime when I found out that I should have had a should have had a registration. And my argument is that I have some evidence. I have a two-bed, two-bath condo, which on occasion I've rented both individually and as a shared situation. When I found out the information when I got a letter in the mail, at the time I got it, I wasn't here, I wasn't in the country. So when I got the mail, I immediately contacted Suzanne and the vacation boards, and Mr. Stark gave me the information as to what I needed to do immediately to rectify the situation. Right away, I paid the TOT tax due over the next couple of weeks, paid the penalties, paid the interest, and paid the outstanding registration fees, several $1,000s. And that was all due, and that's what I was supposed to do. I'm requesting a dismissal, or at least a reduction in the $5,000 fine based on an Eighth Amendment issue regarding excessive fines clause. The excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. 1989, Browning Ferris Industries versus Kelco Disposal. The Supreme Court held that the clause applies to fines when a government entity is involved. And in 1963, Hale versus Morgan, State of California, the excessive fines clause, the clause applies in both civil and criminal fines that are grossly disproportionate to the offense. It must bear some relationship to the gravity of the offense, and to ambush an unknowing landlord converting the wrongful act of the latter into a veritable financial bonanza cannot be considered fair under the fines clause. So I believe I've paid fines, so I paid the TOT tax. I had to pay a penalty for being, as a punishment for not having my registration. I had to pay interest on that as a punishment for not having the registration and not having everything in order. And I had to pay my outstanding registration fees, which I did, and of course the appeals here today. So that's in relevance to those. Secondly, I believe that the regulations were poorly notified, and I can understand the prosecutor is going to say, well, that's just too bad, you should have been aware of them. But as somebody who has been advertising and the vacation people were aware of it, I feel it's reasonable to request that, considering they had this information on me, that they would have emailed, they would have texted, or I would have got a letter informing me that I had X amount of time to fulfill a requirement regarding getting registration. And as a citizen and a long-term resident of Palm Springs, I accept the punishment. I feel I've paid huge numbers of tax relative to that fees due to that. And I have now paid dearly for that transgression, and further fines create a danger of overboard and arbitrary application, I feel, in my case. So I'm not denying that I broke the law. It appears no distinction is made between commercial and individual vacation renters. And this is again in the $5,000 amount. That's what we're speaking about. Those with or without complaints and those who have fulfilled all city requirements. As an individual who has completed all the requirements and payments at this time by credit card, punishment for my past violations is keenly felt. Is another $5,000 fine really proportional to the crime committed under the due process clause? That's the argument I'm taking at this stage. So I have attached information regarding a recent email received from Airbnb, which was, believe it or not, on December 19th, which sent, I believe, to all members in Palm Springs, which was updating all the Airbnb people regarding the situation. It was sent on December 19th of this year, or December 19th of this year. And it was telling you, you need to get your stuff in order because Palm Springs has strict regulations and you need to make sure that you're fulfilling those. So that's one argument regarding the lack of communication and information. The first one was, of course, no email, no registered mail. I signed nothing to receive the information that I needed to have certification. And thirdly, I've attached an American Airlines ticket. I was out of the country from 9/16 till the middle of October. Like many snowbirds in the city, they're gone here in the summertime. I was back in my country, and I did not pick up any snail mail until the end of October. And that's when I reacted right away to the vacation board and followed through with Suzanne and with Stark, I believe it is, yeah. On receipt of the snail mail, I'm now aware of the policy changes. I contacted the city. Vacation rentals were promptly and presented a credit card for all outstanding bills, including the TOT. I've attached also so what I was saying is the City Vacation Rental Agency has confirmed, Natalie has confirmed that I've paid all my TOT taxes and fees and everything related to that. And then finally, there's a federal tax summary. I'm requesting under financial hardship again, and I had no federal tax due in the last 2 years. I know that the appeals board is provided with a recommendation from the city, and the prosecutor has made that recommendation. And I hope my brief presentation and evidence will provide some possibility that the citation will be dismissed. The people are the city. I am a member of the city for the last, since 1999. I'm a registered voter and a resident since 1999. So I'm not denying that I broke the law. The argument here is, do I deserve, under the 8th Amendment and the other arguments I've made, that I deserve an additional fine of $5,000 at this time? Mr. Prosecutor?
Thank you, Mr. Walsh.
Thanks.
You can take your seat.
Do I get to respond if the prosecutor has things to say?
We'll see.
We'll see. Okay. All right. Thank you, gentlemen, ladies. Thank you.
All right. At this time, are there any public comments regarding item 2 on the agenda? Apparently no requests and no comments. And so any board member questions of Mr. Walsh? Mr. Walsh, you want to step back up, please? Mr. Conander?
Thank you. And thank you, Mr. Walsh. Just a couple of clarifications. Did you know that there was a form of regulation and permit required to run a vacation rental of less than 28 days since, I believe, 2008?
No.
Did you know that in 2011 when you first signed up for Airbnb to
I don't believe it was that early.
it says in the documents here that you first signed up with Airbnb in 2011. We have some recommendations.
So I'm not denying the fact that I did rent without a certificate. That is not what we're talking about here. I'm not going back to what the last people went through. The prosecutors made it very clear. You broke the law, you pay the consequences, okay? My argument here today is that, yes, I broke the law. Yes, I now pay the consequences. I just believe that having paid huge amounts of penalties and interest on that for the last number of years, that I feel that it is unfair under the 8th Amendment and under the other issues regarding, I'm appealing whether it be the 8th Amendment, whether it be the issue regarding my own finances at this time, whether the fact that I didn't get the information. There are several other arguments which may be agreed or disagreed, but I feel I'm not disagreeing that I broke the law, but I feel that I have paid huge amounts of penalties and interest related to that. That's what I've done over the last month to 6 weeks with the Vacations Department. I'm now fully in compliance. So I'm here appealing the $5,000. I've no intention of, in recent months, in recent years actually, most of my rentals have been longer than they're month to 3 months to 6 months. So as I've told the Vacation Department that there's going to be nothing shorter than that in the future. So
all right,
my argument here today is for a a reduction of the 5,000 or a dismissal of the 5,000 because I have paid several thousand already in fees and interest. So that's my argument at this time.
Thank you.
Thank you very much.
So, Mr. Walsh, can I ask
Yes,
one more
certainly.
question? Is the reason you didn't take the plan that they offered to get into compliance? Were you
Well,
offered that?
I think there's a kind of a, if you take the plan, you can't appeal. Is that correct, Suzanne? Is that correct? Yes. So if you take the plan, you can't appeal. So the plan would also, I think, would enable me to rent the apartment on a short-term basis, and I'm not interested in doing that. Is that correct?
That's not correct.
That's not correct. Oh, okay.
He had the option with the corrective action plan of agreeing not to rent it again short term.
Right.
But
Which is
he's
the case.
correct when he says that under the corrective action plan, he would have had to pay the $5,000.
So that's the reason I'm here. I'm not going to be, the argument is that I don't feel, it's not that I don't want, kind of, you guys are going to make the decision today, but I have paid a penalty of $2,100. I have paid interest of $400. I have paid registration fees. All the back stuff is up to date. And I have paid the appeal fees. So I feel under the circumstances, under the 8th Amendment, the excessive fines clause, and the changeable regulations, and the information, as I said, from Airbnb, which just came last month. I was out of town when I did get the information, so there was a small delay in that. In getting that information by snail mail, I can't understand why. It's so amazing. When I decided to make the appeal, I immediately got response by both phone and by email from the city, but there's no regulation at the moment whereby any vacation or anybody making is given a heads up regarding the situation. In other words, that you need to have certification. Why wouldn't somebody get an email or a call or some sort of a communication from the city regarding that? But so be it. That's the way it was. I don't want to continue that argument. I feel it's more relevant regarding the 8th Amendment, if you've read what the 8th Amendment says, and regarding the fact that my own finances and that I have paid penalties and interest.
All right, sir. Thank you.
Thank you, sir.
Any other questions?
Could you just summarize again the fines that you said you paid, the penalties you already paid?
I paid the TOT tax due. I've paid the penalty, which amounted to $2,100. I paid the interest on the penalty of $397. Paid the outstanding registration fees of $1,350, and I've paid the appeals fee today of $764. They're all on a credit card, which will take time to pay. So that's the answer to your question.
Any other questions? Anything further from the staff? Thank you, Mr. Walsh.
I think it would behoove us to make a complete record with respect to the efforts that the city has undertaken to get word about this ordinance. Also, I have to tell you, I have tremendous respect for the intellectual integrity and the coherence of the presentation. It's nice to have an appellant who wants to pursue his appeal and actually cuts right to the facts before the appeals board. So thank you very much for that. On a legal level, this is not a violation of the 8th Amendment. I received this document today, or I would have had a case or two to cite myself. I haven't done the legal research. It's not cruel and inhuman punishment for a city to regulate a very highly sensitive use and impose a $5,000 citation administrative fine. Again, I would point out that if we imposed a lesser fine for this type of activity, many of the perpetrators, many of the violators in this area wouldn't even feel the fine, wouldn't even realize any significant financial consequence. I recognize the appellant made the point that there's a distinction between commercial and certainly personal or individual short-term vacation renters, people who make their property available for rental. When we impose and create a standard, we impose a single standard. We do allow for payment plans. We understand that it's a very significant fine, but it's certainly well within the realm and range of what's reasonable and customary and ordinary for significant fines. There are now cannabis fines coming out in the vicinity of $10,000 and $15,000 and $20,000 in certain cities in the state of California. When you do something that's very sensitive and that matters a lot to a community, all the city can really do is impose a very significant fine and hope that people, particularly people who engage in the conduct over an extended period of time, take the time to learn the rules of the road. If Mr. Walsh had done so in 2011, 2014, we wouldn't be here today. I'm glad to live in the same town as an individual who presents himself so well, but the issues today before the appeals board are not such that there's any real challenge administratively or with respect to this issue presented. It's not cruel and inhuman punishment. I'd like to call on the staff to make a complete record as to the city's efforts to get information about the ordinance out there.
Can I just respond to the prosecutor?
No, sir.
Thank you, Mr. Kotkin. The city has mailed out a postcard to every resident in the city of Palm Springs. The city of Palm Springs has had about, I'm going to say somewhere between 8 to 10 public meetings about vacation rental ordinance. There's been significant media coverage as well in a newspaper and TV in regards to our ordinance on a national and local level. In addition to that, the city of Palm Springs excuse me, has continually updated the website. If you went on the City of Palm Springs website and you look at the calendar, you would see vacation rental information on there. We have done, in what we believe, sufficient notice to our community and to the members who reside and who do not reside here. I do want to make a point that the approximate 9 meetings that were held in discussion for this ordinance did occur in 2016 and early 2017 during what we like to refer to as season when there's a lot of snowbirds here present. In addition to that, I would just like to address 2 things that Mr. Walsh did bring up. Mr. Walsh did comply with our request to pay the penalties, and I do want to compliment him on that. Mr. Walsh was out of the country. Because he was out of the country and we took him at his word, we did extend his window to be able to appeal the citation. We offered an extension to him based on him being out of country. And now what the Airbnb communication that has gone out on December, I believe this is not the first time that this communication is going to come up before the appeals board hearing. What I think for general educational purposes, what I would like to communicate to the board is that Suzanne Severin and myself have been trying to work with Airbnb since we took this office to get Airbnb to send out an email notifying their hosts in the city of Palm Springs. Has taken several months of going back and forth with their legal teams to be able for them to send out this kind of communication. This is the first time that in my experience in the vacation industry that Airbnb has sent out such a communication. I'm not aware that they have done this for any other city. So the communication is a huge success that our department has done trying to work with Airbnb. They are a company that has 45 million hosts and individuals who use their website. They're within many, many countries across the world. So working with them is a challenge, but we have successfully been able to have them focus on our local market and notify the hosts. So I just want to let you know that you will see this communication come up before you in the future hearings. Thank you. I'm available for any questions.
Thank you, everyone.
I'm sorry, may I add one thing to that? So as to Airbnb, what they do is they are willing to work with cities to link pages from their website to our website. It's an educational tool. And again, Mr. Stark and I have been in the job slightly over a year, and we're very focused on education and communication. So specifically what happens is when somebody is a host on Airbnb, they can go to our information on our ordinance, and they do get notified from time to time that we do have requirements to get permitted and how to comply. And we don't know, we don't have access to who's hosting. That's not information we have, but we do know that a lot of people use the platform. It's very popular.
Thank you. At this point, the evidence in this hearing is closed.
Do I get to reply to the prosecutor on the comments?
No, sir.
Will
no,
he
sir.
make more comments?
No, sir.
Does anybody have any questions for me?
My responses to you are not arbitrary, but
Okay,
in accordance with rules of procedure for these hearings that we're bound by, and so I'm simply enforcing that. So we thank you.
I'd just like to make one comment before I step down, if I could.
Thank you for your presentation, and we'll move now to discussion among the board members.
Saved a lot of time regarding that, and I appreciate that, and the city and the board appreciates that as well. And he made timely efforts to come to the city and pay the fines, fees, penalties, registration fees, and appeals fee. It would seem to me that he's making a financial hardship argument regarding the fine imposition, that he's indicated that his taxes indicate no taxes due for the last couple of years, and that that it is a substantial amount of money that he's put on his credit card to come to current. He's indicated a lack of intent or desire to continue with the short-term rentals. That's why he did not take advantage of the corrective action plan. And what I would like the board to consider is offsetting the fine, because in this case it's just an administrative fine of $5,000. The administrative fine of $5,000, Mr. Walsh may very well be right that it is excessive or could constitute a takings, or in a manner inappropriate to have such a large fine imposed, or at least not have any of the discretion available to the city people who cite the fines, issue the fines, to graduate the for first offenders and things like that. But I think what the city, what could be considered is the penalties in the amount of $2,100 plus the interest on those penalties of $397 comes to about $2,497. I think the offsetting the fine by that amount would leave a balance of about $2,503 due if you take out the penalties and interest that he's paid, because penalties and interest are that he's paying is for violating this, the statute, and then the imposition of operating a short-term rental is an administrative fine for $5,000 for the essentially it would be the same conduct. It would appear to me, or it sounds to me like it's the same conduct. I don't think that he should be credited the appeals fee, because I think that it was his decision to appeal it, and there's a fee associated with it, as we are staffed and everything else. But I think it would be fair to consider upholding the administrative decision. However, overturning the administrative fine of $5,000 and imposing a fine of only $2,503, half the amount, approximately, based on his already paying penalties and interest for this case. So that would be a motion I would make at this time, my reasoning behind it.
I believe the penalties and interest that were imposed were on the TOT, and those are separate obligations. Not appropriate for offset one against the other. Otherwise, I think with regard to the constitutionality of the ordinance, I suppose if this board wanted to take on that determination, I suppose it has the legal ability under the ordinance and the discretion that the board has. I suppose it could make that determination, but I wonder how we would determine in which case are we going to do that? Why didn't we do it in the earlier case this morning, or one that happened in December? Or why don't we do it 2 weeks from now? And so I don't think that's an appropriate exercise of our obligations under this ordinance. There's a courthouse across the street. Any citizen is at liberty at any time to file an action challenging any ordinance of the city. But for now, we are here to enforce the ordinance that was passed by the legislative process in this city. And those are my comments. So with regard to the motion of Mr. Cleary, but let me first inquire of, hello.
Hello.
And you are?
Cindy Berardi, Chief Deputy City Clerk.
Thank you. And let me just inquire of the staff with regard to the error that was noted on the agenda. Are there any needs that the staff has in that regard before we take action on this appeal?
No, we're fine.
All right. I note that the error was on the agenda. On the resolution itself, everything is correct. So,
And had anybody reviewed the agenda packet, which is, of course, a matter of public record, they would have seen exactly what this hearing's about. They had notice with respect to the address. I'm not uncomfortable in that respect.
All right. So I'll attempt, Mr. Cleary, to restate your motion, which is to it would be 2A, upholding the administrative decision of permanent ineligibility, and 3A, upholding the fine with the modification that the fine be reduced from $5,000 to $2,503. Is that correct? All right. And is there a second for that motion? Hearing no second, the motion fails. Do we have an alternative motion?
We do.
Mr. Cronander.
Yes, I would move that to adopt the resolution of 2A, upholding the administrative decision, and adopt the resolution 3A as written, upholding the $5,000 fine.
All right. It's been moved and seconded for the adoption of 2A and 3A. Roll call.
Mr. Chair,
yes.
Did you second it?
I thought I
didn't hear that.
I'm sorry. I probably didn't. I second the motion. So it's been moved and seconded for adoption of 2A and 3A. Roll call.
Vice Chair Howard.
Aye.
Commissioner Cleary.
Nay.
Commissioner Cronander.
Aye.
Move.
And as the city clerk indicated, the 2-1 vote under Palm Springs Municipal Code 2.50-060B, the motion carries.
Motion is carried. Thank you. Okay, now we're at item 3 on the agenda, which is the appeal of George Robert Horning regarding 1154 East Racket Club Road. And the earlier indication from staff is that there was a request to continue the hearing on that appeal, and that staff had no objection to the continuance, and the suggestion was that that hearing be continued. Again, I'm not clear on what we say after that.
Well, it would be continued to a date no earlier than the month of February 2018, on a date mutually convenient for the city and the appellant.
All right. And so are you looking for a motion and vote by the board in support of that continuance? or is staff taking that action without objection by the board?
Without objection by the board, we'll simply bring it back.
All right. Any objection to item 3 being continued to a date no earlier than February 1st, 2018?
No objection.
No objection. Fine.
Same item with respect to agenda item number 4, Mr. Vice Chair.
All right. Let me just state that for the record. That's the appeal regarding Mr. Sam Perlmutter and Amy Perlmutter Rosenberg regarding 1148 North Rose Avenue. Again, board members, any objection to continuing the hearing of that appeal to a date no earlier than February 1st, 2018?
No objection.
Fine. Thank you.
That is fine, and that's the matter about which I spoke with Attorney Lena Wade, the Perlmutter matter. The other matter, the appellant contacted the city clerk. Thank you for allowing us the continuance, and rest assured there won't be any other continuances if we agree upon a date with these appellants and there's an 11th hour request like this, we'll be opposed to that motion.
All right.
We say that only because we respect the board's time. We know you blocked out the time to be here. We're very grateful for that. The city's very grateful for that. And we don't want to abuse your time.
All right. Item 5 is approval of the minutes of our meeting of December 4th, 2017. The minutes are included in the board packet for this morning. Is there a motion to approve those minutes?
I'll move that we approve the minutes of the meeting of December 4.
I'll second the motion. Roll call.
Vice Chair Howard?
Aye.
Commissioner Cleary?
Aye.
Commissioner Cronander?
Aye.
Moved. Carried.
Carried. And we're at number 6, which is board member comments and requests.
Chair, I just have a few comments in response to the public comments that we heard earlier. I wanted to see if staff could address the anonymous complaint nature and whether or not there is a method by which we could avoid harassment or false complaints.
Thank you. Chairmember Cleary and the members of the board, when we talk about anonymous or confidentiality, that's applicable in 2 cases. One case is when we receive leads into our department through either email or phone calls and such that there's a possible illegal vacation rental operating. We take those complaints. Individuals, when they call our office, do not have to identify themselves. It's a simple lead. We research it, and depending on findings, we proceed appropriately. There are many leads that are really nothing except people having a second home and their family using it. The other time when we protect confidentiality is when individuals do call the vacation rental hotline to file a complaint against a vacation rental property in the neighborhood. Individuals can identify themselves when they call the vacation rental hotline, or they can choose to decline to give that information. Because of the sensitive nature of the issue and the close proximity of living next to a vacation rental, we protect individuals' privacy who made the claim, so there would be any kind of dispute within a neighbor or a neighbor-to-neighbor issue. What we do on our side, we monitor certain data from incoming calls to ensure that our systems and our resources are not being abused by individuals filing false claims. We periodically monitor the volume of calls coming into the vacation rental hotline along with leads into our system, where they're coming from. We take action, and we have communicated with members of the community who have excessively called the vacation rental hotline. Does that answer your question?
So the system allows for you to know.
Let me just. It occurs to me also that this subject matter is not really on our agenda today, and we've taken the question. And would you like this to come back on an agenda for report and discussion?
That would be my request.
I think that would be. Are you satisfied with that approach?
Certainly.
With your permission, Mr. Vice Chair, members of the board, I'm not going to ask our staff to prepare a written staff report on this. We'll simply agendize it as a discussion regarding anonymous complaints under the ordinance. Is that satisfactory?
Yes. Satisfying to me.
Fine. Thank you, Mr. Stark. Any other board member comments or requests?
Just a question. Where do we stand on whether we will have a council for the board? Has that been delayed until we have all 5 board members present, which seems to make sense, by the way?
Last meeting, I don't think that the board was inclined to take action pursuant to the impetus to get that council, to procure that council. We're at your disposal. If you make that direction, we'll certainly put the wheels in motion.
My comment would be that I don't see that. It seemed like the main impediment in the past has been the absence of our full complement, and I don't see that changing for the foreseeable future. So
I would also add, as you saw today, I am the city prosecutor. I am an advocate for the city's position. But it's crucial to me that the appeals board understand that if I'm telling you something, that you may rely on the integrity of my office. I can't and won't mislead you if you ask me a question with respect to something that's going on. You heard today, I gave you an answer that probably was what the appellant wanted, not necessarily what the city wanted or didn't want, but certainly the appellant would have wanted me to say what I did. The bottom line is that I'm not an advocate for anything that the appellant will ever request. I'm only advocating for the city. But as I hope most people know, public prosecutors, whether they're district attorneys or city prosecutors, if they're coming before administrative hearing boards or standing certainly in front of a judge of the Superior Court and making false representations about something, that's unforgivable. We have to hold ourselves to a very high standard in this role. And I want to point that out only because I'm here, I am an attorney, and I am an advocate for the city, but you may rely upon the fact that if I'm asking you to deny an appeal, that request is consistent with the law as I construe it.
And I certainly don't question that at all. It's just that the idea of an outside counsel has come up before, and there have been times they escape me when they were, but where you have not been able to respond in your position of prosecutor. And that I guess I agree that something like bringing on an outside counsel needs to be discussed with more than 3 of us here. So I'll just table my comments until we have that.
And we will do it for you in a heartbeat if that's what the board wants.
I think we can keep in mind, too, that anytime we feel we're in a position that on an ad hoc basis, we want to request intervention of some independent counsel, I think we have the ability to do that. But what had been on our agenda up till now was some kind of general approach to that issue, and that we were going to take as a preordained solution in advance to a problem that we don't have yet. So I think we should all keep in mind that anytime we feel the need to make such a request, we have the ability to do that.
Okay.
Any other board member?
And Vice Chair Howard, that would include putting a pin in a particular appeal, requesting the appellant's acquiescence, and certainly the city's would not be an issue, to have the board get that independent
That's my
opinion,
point.
if that's something that you ever wanted and needed.
Okay. Any other board member comments or requests? I think I do, maybe 2. One is that I received notification from the clerk's office this week about, or actually probably a month ago, about the availability of the email accounts on the city address. And and here's the city clerk now. And it appeared to me that the addresses are up and running, but that we don't know if there's any mail there unless we actually go and open up that account and see if there's a mail sitting there. Now,
And Mr. Vice Chair, I want to make a comment. You may or may not know the state of the law with respect to this issue. A case came out of San Jose, the Supreme Court of the state of California. And if there are ever Public Records Act requests and we're doing business with you, city business, over your personal email, it's entirely possible that somebody could request to get into your personal email account in order to glean whatever city communications have taken place between you and the city. So our electronic communications and computer resources policy that I'm working on finalizing with the Information Technology Department here at the city in my capacity as city attorney is such that we're pushing very, very hard on all of our users to use city email accounts. There's certainly no cost to you. The city has it available for you. We would appreciate it if we could do business with you over a city email. So I would encourage you all to use those email addresses.
but I got mail from the city the day before yesterday to my personal address. And maybe that was just because I had talked to a member of your office professing my ignorance or confusion. And I guess it was suggested at that time that maybe there's a way on whatever devices we use to have those city emails hit our devices without us, proactively going into the city site. But it seems to me that that reopens that opens the door that we were trying to keep closed.
So if I speaking to our IT director, we can provide you with access to your email account through your device. It stays connected to the city server, so your device in itself doesn't store the emails. It's still stored on the city server, so if we were to receive a public records request, the search would be through our servers, not through your phone. In order to provide you with that access, the servers do have some security protocols. One of them is that your phone will require you to have a passcode. So if you're not used to having a passcode on your phone, you will have to have that. And then two is IT has the ability, if your phone were lost or stolen, to be able to wipe your phone clear so that, obviously our issues weren't in breach out in the public. However, again, if your phone is lost or stolen, you would probably want that anyways. And then last is we would ask that you end up putting some kind of caveat at the end of your email noting, since you are commissioners, that you don't speak on behalf of the city in an official capacity in case you were to inadvertently use your city email account for some kind of personal issue. Other than that, we can provide you with access on your personal devices, whether it be an iPad or an iPhone.
And the alternative to that would be for board members
to log in through the internet and access it through that way.
And what would you suggest would be an appropriate frequency for someone to do that? Would it be twice a week, once a day, three times a day?
I would recommend at least once a day.
Once a day.
Because of the scheduling issues that we have.
Right.
That's really the bulk of what we communicate, as you all know. The bulk of what we communicate with you about is scheduling.
Even scheduling, it raises an issue of going to your personal account.
If we were to get a request from the public regarding all emails from the city to the commissioners, then that's going to be part of the disclosure. And so then we would have to request that you go through your personal email account and pull all emails between the city and you and provide them to us because we don't have access to your personal
My only concern is, going to the government account daily for a scheduling that may only come up monthly, or if I miss a day, I'm just concerned that,
I'm not sure you need to worry about missing a single day, but realistically speaking, if you're checking it every day or thereabouts, I think we'll all be safe. Obviously, if there's a pressing urgency, we'll pick up the phone and just call you.
So from now on, all scheduling for meetings will be done on the government account?
I'd like it if we could, because if we don't, there's, again, not a likelihood, but certainly a potential in the event somebody filed a lawsuit or a Public Records Act request regarding affairs between the city and the appeals board members, where they would look for emails in your Gmail account or in your other personal account. And unfortunately, the Supreme Court, or I suppose fortunately, if you are an advocate of that level of access, the Supreme Court says it's okay. The city business in your personal email account is public record.
What assurance is there that I mean, I would want some assurance that it's not a two-way street, that I can access the city, but can the city also go into my personal account?
Here's what I'd like to do, Vice Chair Howard. Maybe we'll continue through the rest of the month of January, muddling through as we have. Maybe for the next meeting, we'll have someone from our IT department here at the appeals board to respond to these questions, because the city clerk is terrific and he's cutting edge on technology. It's one of the reasons that I think the city council was so happy and the city manager was so happy to have him. But we really do need an IT person, I think, to adequately respond to any of the questions you have. So we've already agendized a board discussion with staff of anonymous claims. And we will add, again, without a staff report, a written staff report, a discussion with the IT department regarding concerns and issues about email addresses. And we'll simply do that at the next board meeting.
You know, it's been so complicated in the last week or two, and we see with three people sitting here and with two members absent, I don't know to what extent they are up to speed on this, if they're checking every day, or because what we're going to be doing, you know, in the coming weeks is trying to put together a quorum for these meetings, which you see how difficult that is. And if we have some people who aren't even getting the inquiry, that's just going to be further complicated.
It'll be incumbent upon us until we have an established system that all the board members have agreed upon to make phone calls and to just reach out to you any and every way that we can. The bottom line is we need you here. We need three of you here, and we're going to make sure that we do our best to communicate with all of you. My belief is that we communicated with all five board members to the best of our abilities about today, and I think we have another meeting now scheduled for the
19th.
The 19th, excuse me. And we're certainly going to need a hearing, I suspect, or a day for hearings in the month of February at some point in time.
And I would recommend that the IT discussion happen when the five members are here, which will happen probably in February. Well, I'm hoping at least one more comes back in February.
Our chair's going to be
and also on the 19th, you do have 5 hearings that you'll be considering, and so you probably will have a very long meeting. And I'm not sure.
My guess is it's only the three of you probably till March, based on the fact that I don't.
That was my understanding.
Yeah, I don't think the chair's back till March, and I think that Mr. Cairns is simply in the Virgin Islands doing the best he can for U.S. Residents down there.
I wonder if this board is the only entity in the city among all the other entities that has this issue of communication?
It's not, but I think our need to communicate with you regarding scheduling is much more intense because of the timelines for these appeals.
The other item I had, which may be also applicable to item 8 regarding future meeting dates, but I just wanted to report that in one of my communications with the city clerk's office this week, when we were contemplating the difficulty of finding a date for the next meeting, I mentioned with regard to my own complications that certain days I'm unavailable or I'm not in the city during regular daytime hours, but I am toward the end of the day. And I'm aware that certain boards and commissions do meet in the late afternoon or evening. And I just put that out as a suggestion, and I don't know how it, whether that's at all workable for either of you, but I suggested that if we really got into a bind and a hearing hearing time during the day was not workable, but we could get a quorum together at, say, 5 o'clock or 6 o'clock, that might be worth a try. So I just make that report, and if you have any input on that.
I would be available for a later afternoon, but not an evening. And also it would mean bringing all of these folks in.
That's understood, yeah.
So a later afternoon would be fine with me after 2:30, 3. But yeah. So I'm fine with later afternoon. I'd prefer that even to the morning. So.
I guess mine would be on an ad hoc basis. It depends on the day.
Okay. All right. All right. And number 7 is city prosecutor reports and comments.
Nothing.
All right. And number 8 is city clerk reports and future meeting dates.
You do have the meeting on the 19th. That will be at 9 o'clock in this room.
That's January.
And there will be 5 cases, and the appellants have confirmed that they're available. And then we will need to schedule a meeting in February.
My only comment is I have to leave no later than 25 after 1. I know it's going to be a big day, but I've got another commitment, a medical commitment that I have to be at 1:45. So,
would this board be interested in starting at 8?
We've started at 8 in the past.
The staff's at your disposal, Mr. Vice Chair. I would say, it occurred to me during the second hearing today, it might benefit the board and it might benefit the staff to sort of zero in a little bit more on the issues that are truly before the board. We presented, obviously, the full case today in the second appeal. Maybe we can streamline that a little bit if the issue is really just the amount of the penalty, for example. If we just put that out there, have the appellant at the podium do what Mr. Walsh did and say, yes, the city's correct, that does shorten the process, as I think you observed during the hearing, Mr. Howard, or perhaps it was Mr. Cleary. We can try to do that and try to shorten some of these hearings, only to the extent that if the operation or rental of the unit is not the question, let's put that right out front.
Yeah, I don't see how we can foreclose that issue, though. If
no, without the appellant's agreement, right. That's exactly right. But I could at least ask the appellant.
Yeah, I mean, if there are some of these matters could be submitted, basically, without a hearing could be waived.
Yeah, if the appellant in writing is saying, I did operate the unit and I didn't have a permit, then it could be submitted subject to the appellant's comments with respect to the fairness or the reasonableness of the penalty. I mean, we'll play it by ear, but if I see a particular hearing where I can interject that way, I'll try to do it. And again, you're correct 100%. If the appellant doesn't want to agree, then the appellant doesn't have to agree. We have to prove everything.
I mean, both cases today, I think we kept as tight a rein on the time as was appropriate, and we see it took as long as it took. And
I agree. I don't disagree with any of that. I don't want to play any more of an activist role in the proceedings than the board is comfortable with. That's why I'm bouncing it off you. But given your comments, I think we'll just keep it the way it is.
But I go back to the question of, would you like to begin at 8, or are you good with 9?
8:30 to 12:30. How about that?
Or I can stay as late as, at least. My obligation it requires me to leave at 1:25. Will be done by mid-February. Then I can stay as late as we need to.
Can you?
And on a really personal basis, starting at 8 means I need to get up and out by 5:30 or 6. So I would.
8:30.
I love 9 o'clock actually, but Like we could start at
Are
8:30.
you able to come back after your medical appointment? Say if we recessed for 2 hours or something like that?
Yeah, I probably could, yeah.
All right, so worst case scenario, we'll do what we can, and then we'll re-adjourn.
And that's only going to
or
be
reconvene.
through the first week, I think, of February. So there may only be the 19th that is.
So it
at
sounds
all.
like 9 o'clock for the 19th.
Thank you.
9 to 1, is that what we're doing? You're available till 1?
Oh, I'm available till like 1:25. But, you know, I just had needed to raise that now rather than coming in on the 19th.
And we'll do our best, as you said, Mr. Vice Chair, to keep things as tight as possible.
So will we. All right. That exhausts our agenda for January 4th. We have a motion to adjourn.
I move that we adjourn this meeting.
Moved in second. Roll call.
Commissioner Cronander,
Aye.
Commissioner Cleary, Vice Chair Howard.
Aye. Thank you, everyone.
Yeah.